All right, we're live.
All right, good morning, everyone. This is a joint meeting between Senate Health and Welfare and Senate Judiciary Committees. It is April 16th, and welcome. This morning, we're going to talk about residential care programs in the state, or residential programs for kids in the state, and providing some oversight, trying to understand some of the issues related to our licensure of residential programs for children, and then get into some of the more concerning issues that we have had before us in our committees related to the Kern-Hatton School, among other areas. So, Senator Sears, did you want to say anything before we started?
I thank you for pretty much organizing this meeting and putting together the agenda items. I think it's important for us to understand the process of residential licensing for treatment programs. Having run a treatment program for years, I'm familiar with licensing, but in these larger institutions. And I think I also need to understand what happens to Kern-Hatton if the State Board of Education takes away their license, and also who's overseeing what's going on right now, given that they gave away their residential treatment license. And I'm particularly concerned about mandatory reporting. What appears to have happened at Kern-Hatton and in other places, but from what we heard in testimony in Senate Judiciary, when we were dealing with S99, was a failure to report by both the institution and people who worked there, child abuse. And that's deeply concerning to me. I don't know how much the Department of Children and Families spends each year trying to train people in being mandatory reporters. I know there's been a lot of interest in that. And I'm really particularly, and the Senate Judiciary Committee wants to hear if we should improve our laws regarding mandatory reporting, and how institutions like Kern-Hatton, who fail to do the fail to have mandatory reporters report incidents of child abuse, how they should be dealt with.
So thank you for that. And to that end, the issues that you've outlined are the very issues that we have asked first our legal counsel to bring to us and talk about with us, respond to some of the questions that we've had. And then after that, we'll hear from Commissioner Brown of DCF. We do not have education here with us today. It's our understanding that the Education Committee will be taking this up separately when the AOE report is complete. But we do have ledge counsel from Education here, so we'll get a broader spectrum of information going forward. So thank you all, committee, for being here a little bit early. I think we should probably dive in. We did ask ledge counsel to respond to some of the concerns and questions that Senator Sears has enumerated. And Katie, you are here. So do you want to begin, or do you want us to keep with the schedule with Eric going first? It's up to you.
I'm happy to kick it off.
Okay. Is that okay with Eric? Yeah.
Katie McLean, Office of Legislative Counsel. Legislative Counsel was asked 3 questions with regard to Kern-Hatton. And so it crossed a number of attorney subject areas. So there'll be 4 attorneys at some point kind of jumping in to answer these questions. The first question had to do with the current regulatory structure at Kern-Hatton. So myself and Jim Demaray are going to answer that. There was a question about mandated reporters, and when Bryn Hare is able to join us, she'll be addressing that question. And there was also a question about liability. And so Eric will address that question. So the first question, in terms of what is the current regulatory structure, it's our understanding that Kern-Hatton held a Department for Children and Families license as a residential treatment program, but agreed to voluntarily relinquish that license. And as a result, DCF now has no oversight over the Kern-Hatton facility and no longer performs regular reviews or site visits of the facility. But DCF would be involved with Kern-Hatton only if it received a complaint of abuse or neglect about a child who is currently or was previously at Kern-Hatton. In that case, DCF is still authorized to conduct investigations at Kern-Hatton for individual complaints of child abuse and neglect, as it would for a complaint of abuse and neglect about any child in Vermont. And then in terms of the AOE oversight, I will pass that question to Jim.
Good morning. For the record, Jim Damer, the counsel. So in Vermont, there are two regulatory oversight. Well, I should say that strongly, actually. There's approved independent schools, which have a higher touch regulatory oversight, and there are recognized independent schools, which have a very, very light touch. The approved independent schools are schools that have been approved by the AOE, looking at numerous factors, and they are able to accept public tuition dollars. The recognized independent schools are able to count for the student in terms of truancy. So very, very light there in terms of what it actually does. This educational program at those schools has to have a minimum course of study according to the AOE rules, but basically it's a very light touch. In fact, once a recognized school applies, files an enrollment notice, then it may provide educational services. So it doesn't even have to be approved. Once it submits an enrollment notice specifying various factors, then it is automatically able to operate unless the secretary finds an issue, and then there can be a hearing about that. There is no investigative authority of AOE in terms of recognized schools. Aside from the hearing, there's no express investigative authority as there is for approved independent schools. The things that recognized schools have to do are to provide training of staff in child sexual abuse. That's true for recognized, approved, and public schools. They have to do criminal background checks on employees and contractors, which is also true for approved and public schools. And they have to check with the Child Protection Registry. So those they have to do. And beyond that, just looking at the memo for a second, to point out that, as I mentioned, there's no express investigative authority of the state board or the AOE looking at recognized schools. And there is a duty of care under Title 16 that is to prevent exposing students to unreasonable risk, but that only applies to school districts, not to approved or to recognized schools. So I guess in summary, I would just say that the regulatory oversight, if you can even call it that, for a recognized school is very minimal.
Thank you. And as I indicated earlier, the Education Committee will be looking at this information and at the AOE role in all of this. So, but I think it's important that we all understand the different levels of either oversight or lack thereof, which we're hearing about. Go ahead, Senator Sears, and then I think Senator.
Okay.
Senator Sears, go ahead.
I think this raises a lot of disturbing questions for all of us. listening to the testimony on S99, which should be coming up soon in the Senate, which is a bill that eliminates the statute of limitations on child physical abuse. We heard from survivors of Kern Hatton. One woman was in her 80s. So we have this allegedly, this institution that has had a great deal of at least alleged child abuse go on. I don't know how much has been actually substantiated. And now we have, if DOE drops out, and DOE's oversight is limited anyway, and DOE law drops out, we have no one with oversight over this institution in the state of Vermont. And yet people will continue to send kids there. And I'm really concerned about how we square that with what we've already uncovered. So,
Senator, you have
great.
expressed it very well.
Thank you.
Yeah, no, I think that's a huge concern. So we'll stop for a couple more questions. One, Senator Nitka and then Senator White.
I'm just wondering, could I ask a question of Jim with regard to, I didn't hear if you said that the recognized school, if they need to check, do they need to have fingerprints for their employees? I know you said they had to check the registry, but do they have fingerprint checks required or not? I didn't.
They have criminal background checks required, fingerprint checks. I'm not sure. I have to look that up for you. So Nicola, so give me a minute, but yeah.
Okay.
Definitely criminal background checks and definitely the registry.
Okay, Senator White.
Sorry, this is a question for Jim. I didn't hear whether there's a difference in the independent schools of whether it's a residential school or just a day school. Is there a difference in how they're treated?
In terms of this discussion, no. If they're an approved school, they could be an approved school for special education. I don't think that's the case here for Kern Hatton. I don't think they have special education students, if I recall testimony. But in terms of recognized versus approved, there is nothing around residential there. It's just basically regulation of approved versus recognized.
Okay, so if it's just a day school, it would have, or if it's a residential, it would have the same light touch as if it were just a day school.
I believe so. I see nothing in the regulations on recognized schools that distinguish between
Okay,
residential and day school.
thank you.
Put it that way, yeah.
Thanks.
Any other questions? I think mostly of clarification at this point. Okay. So we can move on. Jim, is there anything else that you wanted to add?
I omitted to say only that the recognized schools are required to adopt hazing, harassment, and bullying policies as are approved in public schools.
Okay. All right, thank you. And I know that, well, we'll get to our discussion with the commissioner, but I do know that the Kern Hatton School did have provisions for support services, and that's something we want to hear about from Commissioner Brown. Who is next? Is it Eric? You're still muted. You're still muted.
Thank you. Sorry about that.
Okay.
Good morning, everybody. This is Eric Fitzpatrick with the Office of Legislative Counsel, continuing our discussion of some of the legal background principles underlying the Kern Hatton situation. I was asked to look at the potential for whether or not the state itself could be liable, liable on damages or liable for any monetary compensation for any of the alleged abuse that happened at Kern Hatton. And that's really a very fact-specific question, but it turns on sort of what the state's role and continues to be, but what the state's role was with respect to Kernhatten. And by that, I mean, what actions did the state take or not take, or what knowledge did the state have or not have? And that's going to be very fact-specific inquiries, into the circumstances of what happened. I certainly don't have that information available, but I can certainly lay out the general big picture legal standards that would apply in this situation so that the committee can be aware of that. As a background for a moment, I should mention that those legal standards are coming from what's known as the Vermont Tort Claims Act. This is a chapter in Vermont law, chapter 189 of Title 12. And it's a particular type of statute that all 50 states have. The federal government has it as well. It's a Tort Claims Act is a statute that essentially through which the state says how it can be sued or how it can't be sued, how it might be liable for damages, how it isn't liable for damages. It's very common, as I say, all 50 states have them. And this sort of legal standards I'm going to mention in a moment all sort of derive from that law, from the Vermont Tort Claims Act. So as I said, I think the liability is going to turn on what the state's role was, what actions it took or didn't take. And as far as I can tell, the state's role, potential role, actual role and potential role, there's really three different pieces to that. And the first, I think you've got licensing as one role that the state had, licensing and inspection. You've got placement, and again, potential that the state may or may not have placed children at Kernhatten, and the investigatory role, whether or not there was knowledge and reports made to the state of abuse and what the state did or didn't do in response to that. So back to the first of those three, the licensing role that the state has. I think, as you've heard and know very well, the state does have a licensing role with respect to Kernhatten, potentially inspection role as well, but there's no liability for that. That's a pretty clear point that the Vermont Supreme Court has expressly held quite clearly that under the Tort Claims Act, the state's role in licensing facilities, inspecting facilities, is not something for which they're subject for liability for damages. So that's a pretty clear answer on the licensing piece. On the second role that I mentioned, which really has to do with placement, and I don't know whether or not the state ever did place any children that were in its custody at Kernhatten. I don't know the answer to that question, but if the answer is yes, if the state did place children there, then and they did so, then it turns on, well, what was the state's knowledge at the time? Was there some knowledge that either the state actually had or could be charged with having? In other words, that they should have known based on the facts and circumstances involved. If there was some knowledge that abuse had been occurring and the state still placed children there, despite having that knowledge, there is a potential for liability. That would be, if you think about it, it's the sort of general tort claims of, violating a duty of care or disregarding a risk of harm, those sorts of principles that apply in the civil liability context that would obviously potentially be an issue if the state had knowledge that there was abuse going on and placed children there despite that. So that's one possibility is the placement issue. And the last one really has to do with the investigatory role of the state, right? So if reports of abuse are made, the state has an obligation to investigate them. So the question is, again, factual question, I don't know the answer to, were reports of abuse made to the state contemporaneously with it occurring? Now, that's a historical question. I don't know the answer to that. But again, if the answer to that question turns out to be yes, if it turns out that yes, reports were made, then the possibility of the state having liability turns on how the state responded. How did the state react to those reports? And the Vermont Supreme Court happens to have addressed this exact issue as well with respect to child abuse reports. And the answer that gave really was, if the state responds to those reports by not investigating at all, in other words, report of child abuse is made, state doesn't investigate, there's a potential for liability in that situation, possible civil liability on the part of the state. On the other hand, if the state did respond and do some investigation, and the claim is just that the response was inadequate or in some way not what it should have been, in that case, actually, there is no liability. That falls under what's known as the discretionary function exception to the State Tort Claims Act. In other words, you're just alleging that someone didn't, in a matter over which the state actor had some discretion how to respond. There's a specific exception for that in statute, as opposed to not responding at all. In that case, there'd be liability because there's no discretion involved in failing to respond. Say there's a legal obligation to at least respond somehow. So sort of recapping then, you've got, as I mentioned at the beginning, all this potential for state liability is something that has to be developed over time through facts. But with respect to the state's licensing role, does not appear to be any potential for liability. With respect to placing children at the facility, if the state did place children there with knowledge that their abuse had occurred, then there's a possibility of liability there. And if reports of abuse were made to the state and the state didn't respond at all, a possibility for liability there. But if the state did respond in some way, then probably no liability based on sort of the adequacy or manner in which they responded. That's a summary. I should point out that overlaying all of this is a point that Senator Sears made earlier, which is that all of this also is very much connected to the statute of limitations. So in other words, when did the alleged abuse occur? Because there's a very strong possibility that the older these cases are, they would be barred by the statute of limitations anyway, depending on what kind of abuse it was. So you may recall that a couple of years ago, the legislature passed a statute that repealed the statute of limitations for claims of childhood sexual abuse. Remember, we passed that and that was retroactive. So if any of these claims involve sexual abuse, there's going to be no issue with the statute of limitations because of the law that the legislature passed 2 years ago. That those can be brought at any time, whenever the victim is ready to bring the suit. However, if it's physical abuse of a non-sexual nature, that has a 3-year statute of limitations. So those had to be brought. And I should point out too that those sorts of claims, the statute of limitations does not run while somebody is a minor. So the 3-year statute of limitations for a child victim wouldn't start running until the child turned 18. So the child would have until they turned age 21 to bring suit based on physical abuse, some sort of physical injury, of a non-sexual abuse nature. But that may have passed. That clock may have passed for many victims, depending on when this occurred. So as Senator Sears mentioned, there's a bill that the Senate Judiciary Committee passed out last week or the week before, I can't recall now, that repeals the statute of limitations in the same way that the law did that you passed 2 years ago for child sexual abuse claims. This repeals it for child physical abuse claims. So that would permit victims of physical abuse going forward, if it passes, obviously, that would permit these claims to be brought, if there is a claim, anytime in the future, without having the claim barred by the statute of limitations. So that's sort of a point to keep in the background of whether or not the state has any liability, because it obviously will turn on that as well.
Eric, thank you. That's very clear. I mean, this is an issue I think that our committee will want to dive into thoroughly, and understanding how those complaints of abuse are made through district offices, and then the frequency and intensity of those complaints, I guess, would be important for determining whether or not the state has acted appropriately in its response.
Yes, that's right.
Okay. All right. So any questions of clarification for Eric on this, in this area? This is an area that's going to take some time to go through. I think in our committee in particular, and then it'll spill over into the other committees. No question about it. Jim.
Just wanted to respond to Senator Nika's question about fingerprints. They are required by public schools, approved independent schools, and recognized schools have to get fingerprints for employees and contractors.
Very much.
All right, thank you. Eric, thank you. You turned your picture off, but we appreciate your time. Thank you very much.
Happy to help, sure.
Okay, and I think Bryn is next. Where'd Bryn go? Where did Bryn go? She left. Who's next, Katie? you
I
go-
believe the last question was the mandated reporters question, and Bryn had planned to address that. It may have been that we had scheduled from 8:30 to 9, and she may have had another commitment to another committee at 9 o'clock. I'll email her and check in.
Okay. I think because this is an area that both of our committees have significant concern about. And we worked several years ago on the mandatory reporter law and statute. So knowing who is responsible for making reports, how those reports are made, and then the consequences of not reporting are critical to understanding Kern-Hatton. Senator Sears, I know this is
Yeah,
a big area for you, so why don't you go ahead?
yeah, and I do want to add, and I did speak with Commissioner Brown about this morning, and have spoken to him in the past about it. We are getting bombarded in Senate appropriations, and you may be as well, on emails from people urging us to fund $117,000 for Prevent Child Abuse Vermont for training and for mandatory reporters. And I know the department has been putting a lot of effort into training to make sure that mandatory reporters are doing their job. And we'd rather have them err on the side of caution and maybe report something that they suspect, particularly child physical abuse. And this all started back during the Desiree Sheldon case, if you can remember, years ago, a young girl from the Rutland area who was murdered, and there had been evidence that she had a series of child abuse cases with broken arms and so forth. So I've got to take care of the dog.
Okay, and I
But
think.
I'll be right back. Thank you.
Right. So, but the issue you raise about within the big bill on our Prevent Child Abuse Coalition providing training for reporting is, and I did hear from Commissioner Brown about that. So I know it's happening, but the more it happens, the better. So the more training we have for folks on how to report, when to report, and the frequency of reporting, I think is going to be very important going forward. So I see that Bryn is doing a walkthrough in another committee. So what we'll do is we'll shift over to DCF, and Commissioner Brown, thanks for being here with half of your team. I know that the other half is unable to be here. But our questions really relate to the process for granting and revoking a residential treatment program license, and not a real superficial review, but rather some depth, as much as we can get today, and then walk through how a complaint concerning a Kern-Hatton student might be addressed, how that complaint might be addressed under the child abuse and neglect process, because we're hearing that is very important, and how mandatory reporting occurs through DCF. So those are the two areas to begin with, and then we'll move on from there. So thank you for being here, Commissioner.
Yes, good morning. And as I'd indicated earlier, Jennifer Benedict unfortunately couldn't be here today. And we hope she recovers quickly. And with me, I do have our General Counsel, Jennifer Micah. We do have a short PowerPoint that will kind of highlight some of the overview processes that we can discuss in a little more detail. And Jennifer will walk us through that, and then we'll be able to answer your questions as well as we go through it.
And just for the committees, as we indicated earlier, the goal here is to understand what improvements we can make to the process. So as we learn more about what has happened with Kern Hatton, then each of our committees will make recommendations, statutory recommendations to improve the process. Thank you. Go. Do you have share screen?
I believe Nellie was going to pull it up and and as Jennifer walked us through it.
Okay. Nellie, you're all set then?
Yep, I'm all set. I will bring that up. Shall I step in now, Sean?
Sure, please, Jennifer.
This is Jennifer Micah, General Counsel for Vermont Department for Children and Families. Before I start, I do want to remind the committee of the limitations of my expertise in this area. Jennifer Benedict is the supervisor of the RLSI. She's the director of the RLSI division, and she really is the one with the expertise. So this is going to be fairly broad, but I think the biggest mistake I could make today is in misrepresenting how the RLSI operates. So I apologize if you're unsatisfied with my answers, and we will try to get you the answers that I can't answer today. But we can go through it on a sort of overview and take back any specific questions to Jennifer when she's feeling better. So we can go to the next slide, please. So before I start, there are two things that DCF does. One is we investigate individual allegations of abuse and neglect. That happens throughout the state in any situation where we get a call of abuse or neglect of a child. The other one is our licensing function over residential treatment programs. Those overlap sometimes because our licensing implicates child safety. So we license and regulate we call them RTPs, residential treatment programs, foster homes, kin homes, agencies that place children, and designated shelters for young adults. Special Investigations Unit does the child safety and interventions, which are the assessments and investigations, which that is the situation where you have an allegation of abuse or neglect. Okay, we can go on to the next slide if there aren't any questions yet. This is the organization chart.
Jennifer, what I'm going to say is, because I can't see everyone, and so if a committee member has a question of clarification, then please just speak up and offer your question. Thank you.
So you can see we have a number of the FSW means Family Services Worker, and we have them throughout the state, and they investigate in their region, in their regions. In addition to having a main number that people call for a particular allegation.
And I would point out in response to some of the concerns raised by Senator Sears regarding mandated reporter functions and training, that we have 2 staff in this unit who do take on the responsibility of providing mandated training to residential programs, so they're fully aware of their obligation under the law of how that works.
I think we can go to the next slide, please. So this is an area that I am not knowledgeable in, the application process for a residential treatment license. So unfortunately, I think we're going to have to wait for Jennifer Benedict to come back and give you an overview of that particular process.
What I could say is that, under Title 33, we're required to promulgate rules regarding the regulation of residential treatment programs for Vermont's youth. And we can provide those regulations to the committee. The link to them on our website, about 50 pages of regulations of how you become a licensed and how we regulate those programs as well. And so we could be able to refer to those throughout questions as well.
So let me ask this question. When was the last time that the handbook and the rules were reevaluated and updated?
I'll have to get back to you on that question.
Okay. That's right. I know because sometimes we hear that rules have been in place for 20 years and without review. So it would be helpful for us to know where these rules are and where the information is for providers.
We can get that to you. The one thing I want to point out around the RTP is that the fact that you have an RTP, a residential treatment program license, does not mean that every child in the facility is in need of residential treatment services. So you could be licensed and as with Kern Hatton, only have a very small number of children who fit within the needs that a treatment program would provide. I'm not saying this clearly, but children with higher needs who need a treatment program, that's the reason why you might have a license. But if you didn't have a lot of children who needed that kind of treatment, then you wouldn't need the license. And you might be more willing to let the license go, which removes DCF from the oversight of that facility. And that's the case with Kern Hatton, that they only had a small number of children who needed a residential treatment program. It was by and large simply a residential school.
So then the question arises, while DCF did provide oversight through licensure, what was the nature of the treatment programs available to the few kids who were there? And then what is the number of children? What's the cutoff point? If you have one child who needs support, that child needs support. So that's a question. And then the other question I would ask is, and as we go forward, we'll have to hear more about this, but are those kids still in the school who are DCF kids in school, state-sponsored children still at Kern Hatton? So that's maybe, Commissioner, you can answer that question.
I can answer. We do not have any children or youth in the custody of the Department for Children and Families placed at Kern Hatton.
And then the other question would be, how many kids are there who require treatment currently? So we'll have to dive into some of this a little more in detail to understand exactly what happened when the licensure was ended.
And I don't have the numbers of how many children need treatment who are still there. It could be that parents could choose to leave a child there even if they needed treatment. But that's not something I can answer today. So we'll have to get back to you on that particular question too. And the other questions about the actual programs, those are really questions for the expertise of Jennifer Benedict.
Okay, thank you.
I apologize for that. I know it's frustrating.
Don't apologize. You can't apologize for someone being sick. Senator Sears has got his hand up. Good, just go ahead, Dick. Yeah.
Yeah, I do. And it's a little bit beyond the application process, but when I was operating 204 Depot, social workers were required to visit once a month with placed children. I don't know if that's still a requirement, but part of that conversation with their kid was often the kid would report things, the social worker would come to me or another staff member and discuss the concerns. And then sometimes there were actual, reports. Other times it was cleared up between the kid and the staff member or myself. I'm wondering if that's still the case, number one. And number two, did you get reports regarding Kern Hatton from social workers who visited there? And would that bring another licensing visit?
I don't know the answers to those questions. We'll have to ask Jennifer Benedict about those. I do know
we-
Depot
I-
certainly would have more oversight. I mean, DCF would be more involved in Depot because of the nature of the program
I
more
see.
than Manhattan. But we do regularly have social workers visit when we have a child in custody.
Yeah, and they are still required to meet once a month with the children on their caseload.
But the reason for my question, and it's similar to the question that I had discussion with Colonel Birmingham about, and that is when a kid runs away, frequently if he's picked up or she is picked up by law enforcement, there's often a discussion with the law enforcement officer about the conditions at the facility. And I don't know if any of those reports, so maybe you could check on that as well. And I've asked Colonel Birmingham to report on that.
I'm sorry, Senator, you were going in and out. It was hard for me to understand.
Oh, I'm sorry.
Can you repeat that again?
My question really is, those conversations when a kid runs away, there's allegations that during the I think his name was Mark Davis era at Kern Hatton, that
Phillips.
a number of children ran away. This all came up during our testimony on S99. They would run away, be picked up and returned by the same trooper. And my experience is that when kids run away, they often talk to whomever picks them up, whether it be a trooper or a social worker or a staff member, and say something about conditions. And it's alleged that those kids talked about the abuse that they were afraid of. And that's what I wanted to.
Yeah,
That's
so
my
you're right.
comment.
This is a question that we asked when we heard from the Kern Hatton lawyer early on, and we're still waiting for a response about that. So it would be helpful to know how that information from a public safety officer is treated and whether it actually makes its way, especially if it's a child under custody, but also if it's a child in a licensed facility. Where does that information go? How is it treated?
I would think it would be reported to our
Well,
main reporting number, but
I guess the direct question is, was it reported?
So, and if I could just jump in here, I think what we would need is more information on the dates and timelines for us to go back on some of these questions to check whether certain information came in through our child safety intervention process or through the regulatory process as well, because it could have come in through a couple different avenues depending on who reported it and how it was reported to us, whether it was one of our social workers conducting a visit, whether it was law enforcement based on their interactions with youth or the program, or parents or staff as well. And so we would just need more details to be able to look into our records to make those type of determinations.
Okay. You can, why don't you just keep going?
okay. Next slide, please, Nellie. So this is another area where I do not have the expertise to go through this in detail. I can tell you, pertinent to the Kern Hatton matter, when we get an investigation, when we get a report, we do investigate, and we have several potential outcomes, which are the institution is in compliance, there are no violations. They're not in compliance, in which case we try to encourage them to get into compliance, and we offer them our expectations and opportunity to improve through a corrective action plan, or we notify the program, and then we also notify the program of our findings, both verbally when we're doing this visits and in writing. And the regulatory interventions are reviewed at each licensing renewal, which is, as Jennifer Benedict talked about at the last meeting, every 2 years. Next slide. So I'm not going to try to go through this flow chart with you. This will be something that Jennifer Benedict will have to go through with you, but it does show what happens when we get an intake. And it'll be important when Jennifer Benedict comes back to talk to you about why we accept and not accept certain kinds of claims. Relevant to the Kern-Hatton case here that we're talking about, the Kern-Hatton matter that we're talking about, most of the recent allegations regarding Kern-Hatton involved child-on-child activity. There are historical claims of adult-on-child abuse, but when you get into issues around children, there are issues of consent and not consent, and children behaving in the way children do, sometimes inappropriately, but not necessarily abusively. So it can be tricky to decide what's happening when you have two children engaging in sexual activity. But that is the crux from DCF's perspective of the problems that we're facing in trying to regulate and license Kern-Hatton and other schools of residential schools especially. So we'll bring Jennifer Benedict back when you're ready to have her go through the details of how we do this.
And I would point out that this flow chart is for the child safety interventions, what we would refer to as the Chapter 49 investigations, and not a regulatory matter under their license and regulate responsibility. But this would be how we investigate specific allegations of child abuse. And we receive tens of thousands of these referrals a year through our centralized intake unit, where all of those come into our the department.
So it also, sorry, yeah, I'll ask mine, and then Senator Hardy, you're up next. But it also brings to mind the question about how the policies and investigatory processes are in the residential facility itself. So does DCF review, and that's on your earlier slide, and maybe Jennifer Benedict can help us with this. What's the process internal to Kern-Hatton, for example, when a complaint is made?
Right. So we'll have to wait for Jennifer Benedict to talk more in detail about that. But I will say, piggybacking on what the commissioner said, some of these intakes do then also get referred to licensing if we feel that there might be a violation of the licensing regulations as a result of, for instance, failure to supervise. So that would be a regulatory matter versus the child-on-child activity that we might be investigating in our RLSI, in our what we call the child safety intervention investigations.
It will, but a policy in place might prevent some of the abuse that or the interaction child to child that might occur. So we'll have to just look at that a little bit. Senator Hardy, go ahead.
Thank you, Madam Chair. And Jennifer, you may have just sort of answered what I was going to ask, which was, I understand the complexities of investigating or getting to the bottom of child-on-child sexual contact. But is it true that if an adult or a teacher or residential care provider knows about the contact and doesn't do anything about it, is there not some kind of liability or responsibility for that adult to, as you said, supervisory ability or reporting or intervention responsibilities for the adult in the situation?
Yes. So we're getting into where DCF would like to talk about some of what we see as gaps in the oversight of some of these schools. And DCF doesn't think that it is really necessarily the right department to oversee some of this, but let's say, just as an example, you have a school where children are engaging in what might be considered inappropriate sexual conduct with each other. It is adults' responsibility to make sure that the children are kept safe. Now, in a home, if there were a parent who was failing to protect children from each other in their own home, you could have an investigation and a charge of child abuse and neglect for failure to protect those children. In an institution, it's much harder to get at because there isn't always an identified adult that you can point to who is failing to protect. So you might have an institution that has, for instance, cabins where children are engaging in inappropriate conduct, and you might know that the adult is supposed to be there and they're not. And that might be an easy case where you can point to that particular house parent who wasn't there. But in another case, you might have children sneaking off into an auditorium or going into the woods or going into places where they're not supposed to be, where there's ambiguity about which adult is supposed to be supervising at any given time. So those are essentially the problems that we're facing in investigating and trying to hold accountable institutions for failure to protect, which I think is what what's going on to some extent at Kern Hatton. How do you make sure that that there are a sufficient number of adults and that they're watching the children where they need to be watched?
Senator Lund. Oops, I'm sorry, Jennifer.
No, that's fine. Go right ahead.
Thank you. With regard to the child-on-child activity, if a child complains to an adult, then what's the process?
So the adult, the mandated reporter, should call our hotline and report the abuse, the activity, and there will be and I can't get into the details of it because I haven't been involved in that process. But as a mandated reporter, which is any adult who's working at a school is a mandated reporter, so they should be reporting it, and we would then, as the flow chart shows, we will accept it or not accept it based on the facts of the initial case. If it's a particularly serious case, we might get law enforcement involved too.
And I think depending on the nature of that institution where that occurred, if it's a licensed residential, it could be referred for a regulatory intervention as well as a child safety intervention investigation as well. I think it's a fact specific depending on the circumstances involved, with the conduct, who's involved in the conduct, and then also the nature of the institution where it occurred.
Right. As I noted earlier, if you are an institution that doesn't need the children who need residential treatment, then you don't need a license, and then you avoid that kind of oversight.
Thank you. This is great. Why don't we move on to your identified gaps that you were talking about, and then
Okay.
We'll open up for further questions.
So I've talked a little bit about our regulatory oversight limitations. If they don't want to be a residential treatment program, then we have no oversight of them on a licensing matter. We have no authority to close them. Nobody does, really, as far as I can tell. Maybe Jim Desmarais can speak to that more, but I don't think there's any authority that would allow us or AOE to close an institution. I apologize. I don't understand that second point. I didn't do the PowerPoint, and I'm not sure what Jennifer Benedict was intending with that second one.
Okay, so we'll come back to that. Right, we did hear about national or more regional regulatory activities through the AOE. So maybe that's, we'll
I think
come back to that
other
at
like
some point.
national accreditation that might be out there for like independent schools, we're not
Yeah.
able to share certain information, I believe is the point there, but we would need Jennifer to confirm.
Yeah.
Mhm.
DCF has not revoked an RTP, a residential treatment program license. And part of the reason we didn't want to revoke Kern Hatton's license is because we understood that we were providing some oversight in a situation that we were concerned about. And I don't know what more to say about that, but
Well, I
you
don't
can,
know, but that leaves those of us who may be sitting here hearing that leaves us with dozens of questions
I'm sure,
about what that means. We decided not to take it because maybe you could rephrase that, or
So
should we
Senator,
wait
I guess
to hear?
how I would frame it for the committee is, we had been engaged with Kern Hatton, and this is historical, prior to the General Counsel Micah, my time. But as I came into this role, this is one of the first issues I faced this summer, was how to move forward with Kern Hatton based on our concerns with their program over the last several years, and concerns that they really were more of a private boarding school than a treatment program, and really shouldn't be licensed, and that there were ongoing issues with them, and what was happening with kids in their program. And so from our perspective, the department that's responsible for child protection issues, our one tool in our toolbox was to close their residential license. And if we invoked that one tool we had, we lost ongoing visibility into that program on an ongoing basis unless we received a specific child safety report invoking our Chapter 49 authority to do a specific investigation. However, that would only be specific to that report of abuse or neglect. And so our ability to provide any oversight to that program on an ongoing basis evaporated as soon as we closed their license. And so we were in a catch-22 at the time, I would say.
So if I compare that where Kern Hatton is today with, say, Vermont Academy in nearby Saxon Rivers, you have no authority over Vermont Academy, nor yet, I don't think the state ever has, other than if there was a report of child abuse there, you would obviously have to investigate. Is that correct?
That is correct, Senator.
That helps me a lot because I'm comparing the two programs today. If Kern Hatton loses the state Board of Education designation, then they would be more like Vermont Academy, which I don't think is recognized by the state Board of Education.
and I might add, if you have a lot of out-of-state students, then the AOE designation isn't as important to you either.
Yeah.
So then, that raises a huge number of questions about oversight, period. And this can go on and where the responsibility lies, because these are children. So, and then just to go back to your number one, the first bullet that you have there, where you're closing the license or revoking the license, the oversight that was provided was a result of state children being placed and or treatment necessary for kids. So if the treatment continues, whatever that is, whether mental health or behavioral treatment, why isn't there some, well, should there be, from your perspective, be some oversight for those kids in treatment? to ensure that the treatment services are offered adequately.
So
I'm not sure how to answer that, other than to say if parents have a choice where to send their children. And if they go to a school that chooses not to be licensed as a treatment program, but they're happy with what the school is offering their child, then you get into issues about the rights of parents to choose the education for their children. As just one point. I mean,
and I would say when we were working with Kern Hatton, recognizing, I think they recognized that they really were not a residential treatment program. And we had recognized that, and we had concerns about the way they were operating, and we were moving towards revoking their license when they voluntarily said they wanted to relinquish it. Before we would allow them to do that, we required them to take certain steps to make sure that surrounding states who might refer children to their educational institution were made aware that they were not a licensed residential treatment program, and treatment was not a component of their program. Because as General Counsel Michael indicated, they do receive a number of students from surrounding states into their program. And we wanted to make sure those states and other organizations that referred children there were aware that they were no longer a licensed treatment program, and did not provide treatment, that they were solely an educational institution.
Okay, thank you. All right, are there any other questions at this point for Jennifer
Senator
Micah
Hooker.
or Commissioner
Yeah.
Brown? Go ahead.
Senator
Dave.
Hooker has one.
Thank you.
Oh,
Thank you.
go ahead. Go ahead.
Commissioner Brown, you said that Kern Hatton relinquished their license, but that you were in the process of revoking it. Can you address that? I mean, why was there that revocation that was imminent and then the relinquishing instead?
Well, you always, if when you're working with another entity, whether it's in this area of DCF or other areas, you certainly want to come to a resolution by agreement, if at all possible. And in our work with Kern Hatton, and our continuing regulatory findings of that we were, and our concerns of their treatment program, which we didn't think that they met the criteria any longer to be a licensed treatment program. And they agreed, and then they had agreed that instead of, and they agreed and recognized that and said that we would like to voluntarily relinquish, but we wanted to make sure they met certain conditions before that happened. Had they not met those conditions, we would have then moved forward in a timely way. We would have moved forward at that point to revoke their license, and then ourselves notified other organizations that they were no longer a licensed treatment program. But Kern Hatton was able to meet those conditions, and then voluntarily surrendered their license. And so I think that was the mechanism that moved forward.
So when we bring Jennifer Benedict back in, will she be able to ask more in-depth answer more in-depth questions about this particular issue? Because it's one that I'm very concerned about, and I think other members of our committees are concerned about.
Yeah, and I think, and that's the gap we identified, Senator, is we were concerned too, recognizing what was happening in their school, but that they also weren't a treatment program, and our only tool in our toolbox was to close their license, which shut the door to our ongoing oversight role of that institution.
But you indicated that they would have had to meet certain conditions. So it would be helpful to us to understand what those conditions are or were.
Yep, and we have and we can provide the documentation of the correspondence that we provided to Kern Hatton with those conditions in it, Senator. We do have that documentation.
Thank you. Okay. Any other questions? I can't see hands. Senator Sears, I can see.
Yeah, I just wanted to thank Commissioner Brown and the others from DCF. And it's unfortunate that I can't think of her name right now. I'm stumbling.
Jennifer Benedict. It's okay.
Yeah, Jennifer Benedict was unable to join us today. But I appreciate the effort of both Commissioner Brown and Jennifer Mike. I think that you've actually explained a lot, but also left a lot of information. And I think there may need to be significant changes in the way we license independent schools. When I think of an independent school, I think of Burr and Burton, and I'm sure people from the kingdom could, Linden Institute and some of those other schools, not necessarily residential school like Kern-Hatton. So it leaves with a lot of questions, but I think also you've explained a lot too to help me understand a little better the process. I'm hoping that Colonel Birmingham can shed some light on some of the other issues.
So I think Senator Hardy has a question, and then go ahead, Senator Hardy, and then I'll have a question for you, Senator Sears. Go ahead.
Thank you, Madam Chair. Commissioner, I'm wondering if, given everything that you've learned and processed and shared with us, if you have specific recommendations for what we should be doing moving forward to improve the legal structure, given that that's what we're able to do is make laws, change laws. And I had hoped to see a slide that sort of had your bullet point recommendations. And I'm wondering if you've gotten that far. I mean, it seems clear to me that there are certainly recommendations about private school oversight, which is obviously not in your bailiwick. But if there are things in your area that you think we should tighten up legally, what would they be?
I think, and I would defer to Jennifer Micah to jump in here, but I think, there's the issue of the one tool in our toolbox is closure. So I think if there is a residential treatment program and there's ongoing compliance issues, and we certainly would not want to just close their license and lose visibility and access to that program on an ongoing basis, I think we would want to explore what opportunities are there, maybe to expand our capabilities there or tools in our toolbox. But I think also in general, I think Jennifer touched on the other point, like if this was a private home and it was youth on youth, the parent is ultimately responsible for their children, and many times we do act in those situations, either through a conditional custody order or a family support case, or we take them into custody and place those children in another setting, and we have that ability to do that. We didn't have the ability to do that here, and I think Jennifer touched on that a little bit, on how we would intervene in these situations that could be ongoing of children on children abuse occurring, and who do we hold accountable? Is it the staff? Are there staffing pattern issues that are actually problematic of leadership and resources in the institution, and that's where the accountability lies? I think those are questions that need to be fleshed out and explored more. Are there opportunities to look at for us there as well? But I'm also sensitive that in the other chamber right now, there's a conversation going on with the child advocate where there's been a lot of testimony that we overreach and are too intrusive and too quick to act. And so I think that highlights for us, you're sensing our hesitancy here, that we want to be careful because we do have an awesome responsibility here. And at times we have some pretty broad powers. And when you exercise those, sometimes it creates conflict and I think we're seeing that in between the testimony and the Office of Child Advocate, but then also the flip side here, in this situation. And so we're sensitive to that tension, and we just want to approach it thoughtfully.
That I completely appreciate that and understand that you're in a really difficult situation. And also it seems to me with the residential care treatment facility situation, you're kind of in a catch-22 also, that if you revoke a license, you have no oversight, but if you allow a program that shouldn't be a program to continue, then you're also not doing the right thing. So what is the right thing to do there? So I appreciate that. I think though that we do want to move forward with something, at least as we flesh this out, to improve the system that makes it clearer for you all and also more protective of children in the state and these kinds of programs.
Okay, thank you. And thank you, Commissioner. I'll echo Senator Sears' comments and Jennifer. This has been very helpful. We're getting further down the tip of the iceberg. So, and we'll come back to this again. So, but thank you very much. So Senator Sears, my question is, we have both Matt Birmingham and Bryn Hare here, and I was thinking that perhaps we should go to the mandatory reporter report, Bryn's report first, and then Colonel Birmingham, but I'll leave it to you. And you're muted, Senator.
Sorry, my life on Zoom is muted at the time, and when I don't want something I say heard, I'm not muted. So anyway, I'm fine with, I just want to make sure we have adequate time for Colonel Birmingham.
So yes, so let's do this. Let's listen to Bryn, and we'll try to restrain ourselves with questions and comments and sort of listen, and then we'll move to
We're
Colonel
scheduled
Birmingham.
to break at 10. I mean, we can go a little bit longer than that.
Okay.
Senate Judiciary.
Yeah, we're tight as well. So, Bryn, welcome.
Thank you.
I think we asked a question about mandatory reporters and what happens with a failure of mandatory reporting. So perhaps you could speak to that a little bit.
Sure. And my apologies, I had to leave earlier, but that's the way it goes. So good morning.
Time of year.
Bryn Hare from Legislative Council, for the record, here to talk about what happens if a person who's a mandatory reporter fails to report. So as everybody knows, there's an obligation in Title 33 for mandatory reporters to report to any reasonably suspected child abuse or neglect to the Department for Children and Families within 24 hours that abuse was first received or observed. So a failure to report child abuse and neglect by a mandatory reporter, it is a misdemeanor. The statute, the mandatory reporter statute, provides for a $500 fine for a person who violates the requirement, and also an enhanced penalty of up to a 6-month prison sentence and up to a $1,000 fine for a person who fails to report with the intent to conceal child abuse or neglect. So there is a criminal penalty directly in the mandatory reporter statute. And then also, and I can speak to this more generally, there's also, depending on the employer of the mandated reporter, there could also be employment sanctions for a failure to report, depending on the type of employee. So some organizations impose employment disciplinary action up to and including termination for a failure to report, depending on the person's motivations. And depending on the mandated reporter's profession, there could also be professional licensure implications if a person fails to report. So that would really be up to the board or the agency that oversees that person's professional license. And it would be very fact dependent on the situation. And depending on whether or not that failure to report would constitute unprofessional conduct pursuant to that person's license. And then it also is possible that the mandated reporter statute could create a private civil right of action for a person that was harmed by a mandated reporter's failure to report. There is a provision in the restatement of torts that if there is a legislative provision that protects a class of people by requiring certain conduct, but it doesn't indicate whether or not there is a private civil right of action, a court can find that there is a suitable tort action that was available to a person who's been harmed, or create another cause of action that's analogous to an existing tort action. And the Vermont Supreme Court has said that they have not ruled on this issue about whether or not there is a private civil right of action. In 2018, they ruled that they haven't made that determination, and they declined to make that determination in a case that was before them in 2018. But they did note that there really is a split of authority in other jurisdictions about whether or not the mandated reporter statute implies a private right of action for civil damages against a person who's failed to report.
Thank you. This is an area that both of our committees have worked on in the past, so I think we'll probably be working on it again.
I think
Senator
there's-
Sears, I think
Well,
you're,
I think there's two areas to look at for the future, Brennan, maybe even thinking about drafting. One is it's very difficult to, I would imagine, to prove intent to conceal. And I think we should look at that particular criminal, but I think maybe we need to make clear that there is a civil case against someone who fails to report, that they could create a civil cause of action. And secondly, we may want to look at how do we hold an institution accountable that allows that type of failure to report. There's allegations that Kern Hatton's administration itself encouraged people not to report. And how could they be held accountable? I'm not asking for answers today. I'm thinking in terms of drafting something.
Understood.
right. No, we got that. Any other questions of clarification for Bryn?
And I could provide some quick data for the committees as well in this area. This is calendar year 2019 data. We do not have 20s all put together yet. But 2019, we received 20,078 reports to our child protection line. Approximately 78% of those came from mandated reporters.
Wow. Okay, thank you. All right. Let's move on. Bryn, thank you very much. This is really very helpful. Let's move on to, and for folks who are signing in, Nellie, I think let's hold people in the waiting room if they're coming in for the next part of our meeting, just because it interrupts the flow of what we're trying to do. So let's turn to Colonel Matt Birmingham, and Dick, Senator Sears, you should probably introduce the topic.
Well, Colonel Birmingham and I had a number of discussions about Manhattan, and the main question is the allegations during our work and what we heard in the joint hearing, as well as in Senate Judiciary, was that a number of cases, the same trooper was returning kids who had run away from Manhattan back to the facility. The children claimed that they ran away because they were afraid of being either sexually or physically abused by Mr. Davis. And I wondered about any of that, but also other runaways who claimed that they had been abused. Did they talk to the officer? I know that when I had kids run away from 204, it was frequent that they would say things, some of it true, some of it not. They would tell the officer or whoever picked them up, maybe their social worker or even a staff member like myself, certain things that we were not aware of. Some of it was true, some not. So I asked the colonel if he could go back and look at the records, but also maybe a little bit of information about how runaways are handled by the Vermont State Police.
Thank you. Thank you,
Thank you,
Senator.
Colonel.
For the record, I'm Matt Birmingham, the Director of the Vermont State Police. I appreciate the opportunity to come and speak with all of you. Just for a little background, the state police has specially trained investigators assigned to the special investigation units around the state that deals solely with allegations of physical and sexual abuse against children. So we work very closely with DCF on those investigations that are criminal in nature. Also, for the record, troopers are all mandatory reporters under the law and are required to report any allegations of a child physical or sexual abuse. Specifically to Kern-Hatton, I've run a couple of numbers since January of 2017. In that time frame, the state police investigated no cases of runaway juveniles between that time from Kern-Hatton, but there were 5 active investigations by our criminal investigators related to 4 of them were all child-on-child sexual assault allegations. And then 1 is actually ongoing as we speak. So and that's from 2017 on. The concern, obviously, about the trooper that Senator Sears was talking about in the 80s related to the allegations back then. I don't have specific information at this point on that. Certainly, there are, as far as I know, there are no troopers that are currently still employed with the state police from the 80s. And it would be important for me to dig into those records, which are all paper files at this point. So it will take time to do so and identify which trooper that could have been operating down there at the time. We obviously didn't have special investigators at that time, nor do we have SIUs at that time, and handled complaints very differently. So that's still underway, and it will take some time to figure out who that may have been at the time, but certainly something we are interested in ensuring that we get to the bottom of whether or not that was true or not at the time. So that's what I have for you. Currently, I'm certainly happy to answer any questions from our end. Obviously, when we receive any allegation of physical or sexual abuse of a child, we notify DCF, as does everyone, and then our SIUs are immediately assigned and involved in any criminal allegations from there on out, and criminal investigators work very closely with the DCF investigators on those cases and present those cases to the state's attorneys in the respective counties for prosecution. They are specially trained. They go through child forensic training courses to learn how to interview child victims and learn how to do those types of investigations, which are very sensitive and require a very different approach than many other criminal investigations that we're involved in. I'd be happy to answer any questions.
I'd have a quick question, but Senator Sears, you go first.
No, you go.
Well, I was just going to ask what if in terms of either the training or the contacts with kids and other folks involved, do you work with DCF on this? And then, because I obviously you do work with DCF on this, but in terms of the training process and then the investigation process, how closely and under what conditions do you work with DCF and social workers and so on?
As close as it gets, where we work sometimes in the same offices. We work right alongside their investigators in these SIUs around the state. And troopers are mandatory reporters. So regardless of, if a complaint comes in, and regardless of how it comes into the state police, we're required to notify DCF on any allegation of abuse of a child. And they, at times, can handle some of those reports on their own. And then sometimes if there are criminal allegations, they will come back to the state police and the SIUs, and then we will work right alongside DCF investigators on those investigations.
Thank you. Senator Sears, you're up.
Yeah, I guess my question, Colonel, is I'm assuming that the 4 cases of child-on-child sexual conduct were decided not to be prosecuted by the state's attorney. Am I correct that those have,
Three of them were declined and one was prosecuted.
and the ongoing investigation may or may not be prosecuted by them?
Correct. That is
But
ongoing.
everything
so-
is written, no matter what you do, the decision of whether to charge or not is actually with the state's attorney. In Wyndham County, not the Attorney General, is that correct?
That is correct, Senator. All of those cases that I spoke of, except the one that's ongoing, which I assume is also being closely reviewed by the state's attorney, were reviewed by the state's attorney, and three were declined and one was prosecuted. But these SIUs work very closely with the state's attorneys and their staff, and have, in many cases, specific prosecutors that are assigned to prosecute these cases. As well, because as I said previously, the investigation of these cases is very, very sensitive and requires special training, as does the prosecution of them. So there are many prosecutors designated around the state to oversee and manage that caseload.
I think it's important also to understand that many of our child sex abuse laws were updated in, I'm going to say it was 2010, following the Brooke Bennett case. It was Act 1 that year, and that changed a lot of what has happened. So I think we may have and so when we're looking back to the 80s, that was well before a lot of those changes were made. And that nobody needs to comment. I just think it's important to understand that a number of changes have taken place.
I think Senator Hardy has a question.
Thank you, Madam Chair. Thank you, Colonel, for being here today. You gave us statistics about investigations since 2017. Is there a reason for that? Do you have information on investigations prior to that, is one question. And the second question is, you said you work very closely with DCF on these types of investigations and matters. And I'm wondering if at any point you saw a sort of pattern that concerned you. We did hear from Commissioner Brown that DCF had concerns, and I'm wondering if your people also had concerns. And if you did see a pattern or see a pattern anywhere else at any other place, what do you do when you start to see a pattern where there are repeated cases or situations?
So the first question, 2017 was probably an arbitrary date that people that I asked to look into this look back. Certainly we can go back as far as our CAT RMS records go, which is probably back to 1992, and I can pull those easily. Prior to 1992, which is when our current CAT RMS, which is our computer records management system, went online, everything is in paper files, which are in storage. So it's much harder to access that information. But certainly I can go deeper than 2017 if you like. It was really, I think, just a snapshot in time. To your second question, that's a good question. I don't know. I certainly, that would probably be the local SIU investigative team and the supervisory oversight of both the criminal investigators and DCF side of the house. Whether or not they feel there is some sort of trend or some sort of issue that they want to highlight, and I would leave it up to the local investigative teams to do so. Because all of these, the current one I can't get into, but the four prior to were child on child. There certainly was no red flags that I was aware of that were raised about child physical or sexual abuse by staff or adults at the facility. And certainly if that was the case, we would probably be having, that would raise a lot more red flags. But I would leave that up to the local investigators and supervisors to manage if they feel there's some sort of issue that really needs attention.
Okay, thank you. Other questions? I'm sure that this, again, there'll be a lot of other questions, and as we look back on what's been reported by those involved at Kern-Hatton, we're going to want to know more. And I think some of this does relate to the to the role of the mandatory reporter, and some of it actually, does relate to how to collate the information and determine whether or not it's actionable. So, Senator Sears, I think that this probably is a good time to wrap. And before we do that, I wanted to thank Commissioner Brown and Colonel Birmingham and your staff who are here or who are not here. But I especially want to thank Katie McClinn, who had to leave, for putting this all together with me. We did a bit of planning on this, and Senator Sears as well. So I think that's it. This is not the end. This is the beginning. Again, another beginning, but we have a lot of questions, and really appreciative that the department has identified some gaps, and as we go forward together, continue to identify the gaps that need closure, both in public safety and Department of Children and Families, and then extending into the Agency of Education. So thank you all. This will be the Zoom room for health and welfare. So we're going to take a 5-minute stretch. We'll end the joint meeting with Judiciary, and then any Judiciary members who would like to stick with us, you're welcome to be here. See, you're all excited about it.
Yeah, hopefully all the Judiciary members will come over to the Judiciary Zoom with Peggy Delaney. At 10:15, we're scheduled to start. So
Okay.
we've got time to move to a different room.
Yeah, walk down the hall.
Yeah, walk down the hall. Judiciary is right around the corner from Health and Welfare if you need directions.
All we need is a door between the two committee rooms. We'll be all set. All right, take care. Thank you all. Committee, we'll be back at